this year. You'll probably see me at a few events in parts, so third event. I just have a few preliminary matters before we begin. Please remember to join our twin site, the Federalist Society. We won't be sending out emails to that initial table orientation group anymore. We just feel like it's crazy to send out 2 emails to more or less the same group of people. We also have a Facebook group, which a lot of you have already joined, which is good. It's at Ohio State Federalist. It includes all our updates, upcoming events, links to stuff we're doing, things of that nature. And also, of course, we have our YouTube channel. Videos are updated to Ohio State Federalist pretty much right after events. So it's the same name, Ohio State Federalist. Just come check us out. So today, on behalf of the Federalist Society, I'd like to welcome you all to our third event. This is a discussion on originalism in the modern world with Professor Strang from the University of Toledo College of Law and our own Professor Oesterle here at Ohio State. I'll actually begin by introducing Professor Oesterle, who's actually going to speak second. Our format today is going to be similar to the commentary, so Professor Strang will speak first for about 25 minutes, and then Professor Oesterle will speak, and then we'll take questions from the audience. Professor Oesterle is definitely well known to you all. He's the Gilbert J. Reese Chair in Contract Law here at Moritz. Like me, Professor Oesterle is a Michigan man. He earned his BA from the U of M. Unlike me, however, he actually stayed on for some crazy reason and got his JD at Michigan. I saw the light. He also has an MPP from Michigan, so that's pretty cool. Professor Oesterle has taught at Cornell, and he's also taught abroad in New Zealand and Australia. His research work is primarily based on matters of entrepreneurship law, bankruptcy, securities regulations, things of that sort. Beyond his academic accomplishments, he's a veteran vintage race car driver, and he's also, of course, a faculty advisor here at the Federalist Society, so we're pleased to have him here. Professor Strang is a graduate of the University of Iowa Law School and earned an LLM at Harvard. He was a clerk for Judge Batchelder for the U.S. Court of Appeals for the Sixth Circuit. He worked in private practice for the firm of Jenner & Block in Chicago in general and appellate litigation. Professor Strang is a prolific scholar in constitutional law and interpretation. Most recently, he published a work entitled An Originalist Theory of Precedent, the Privileged Place of Originalist Precedent, in the BYU Law Review. Among other scholarly reports, he's currently editing a casebook on constitutional law for LexisNexis, and he's drafting a book proposal tentatively called Originalism, Its Promise and Limits. We're very pleased to have both these scholars with us today, and so since we've already gone over the format today, please join me in welcoming Professor Strang.
Thank you very much, Amana, and to the Ohio State Law Society and Professor Oesterle for taking the time to offer comments today. I know as somebody who's asked when a speaker comes into my law school to give comments on people's papers, I know that it is a time commitment, and that I certainly appreciate it. If for no other reason, then it's great to get the comments from somebody who's smart on something that you've said. I enjoy giving Federalist Society talks across the country, and this is my second time at Ohio State. I had a great time last time, really good questions and answers last time, so I'm looking forward to questions and comments after our discussion today. The title of my talk is, Can Originalism Get with the Times? How Originalism Meets the Challenge of Change. And the talk is distilled from an article I published a couple of years ago. It's a synthesis of that article. And the article itself is part of a larger project that I've been working on for 7 years to try and describe what I think is a defensible originalist theory of interpretation. One that responds with plausible criticisms. And in fact, I think the criticism we're talking about today, what I call the challenge of change, is perhaps the strongest criticism of originalism that's out there. And also fills in gaps. So originalists have been at work for 20 years writing about originalism, but there are still a lot of gaps in originalism, and one of my goals is to fill some of those gaps. My arguments today presume that originalism is the correct interpretive methodology, and there's a handout up there of a flow chart of how I see originalism, kind of a very simplistic version of the originalist theory of what a judge should do. And even though our talk today is about originalism and change, I'm happy to answer any questions, take any comments on originalism generally. It's something that I enjoy talking about. One of the most persistent criticisms, and also one of the most powerful, is that originalism is not a viable interpretive methodology because of the tremendous social change, technological change, cultural change, and moral change over the 2 centuries and so that the Constitution's original meaning was created. The Constitution's original meaning was created in a context so different from our own, the criticism goes, that a constitution whose meaning was limited by that context would be unworkable today. That's what I call the challenge of change. And my thesis that I'm going to present today is that originalism has 6 tools, 6 interpretive tools, 6 arrows in its quiver, so to speak, to surmount that challenge of change. First, I'm going to explain the challenge of change. Second, I'll describe the 6 mechanisms that I believe enable originalism to overcome that challenge. Third, I'll explain that even with these mechanisms, originalism retains what I call critical bite. And critical bite is the phrase that I use to describe an interpretive methodology that's principled, not flabby, not whatever is the best policy at the moment, something that still is structured and leads to conclusions that we may not always like. Before doing that, let me give you some background on originalism. Originalism is one of the main theories of interpretation today in the judiciary and in the legal academy. Prominent proponents on the bench, I'm sure you've heard of Justices Scalia and Thomas. I think it's fair to say by now that we can count Chief Justice Roberts and Justice Toledo in the originalist camp as well. And then Justice Kennedy's an erstwhile sometime originalist. It depends on how the spirit moves in. In the legal academy, prominent originalists are all across the academy. I think this has really been a dramatic change over the last 20 years. Professor Randy Barnett is at Georgetown, Keith Whittington's at Princeton, Larry Solomon is at Illinois, and there's actually somebody who recently came on board the originalist bandwagon, Jack Baldwin from Yale. And I think what that shows is that originalism is really a theory on the move. It's gaining adherence. The people who are originalists are writing a lot, trying to respond to criticisms, and filling gaps. What is originalism? Originalism is the theory of interpretation which says that the Constitution's publicly understood meaning of its text, when it was ratified, is its authoritative meaning. How do we know what the public meaning was? We look to the text of the Constitution, we look to its structure, we look at the debates in the framing and ratification conventions, debates about what does this text mean. We look to the broader societal debates. So when the Constitution was proposed and ratified, there were debates in newspapers across the country, ministers argued against and in favor of the Constitution. We have access to a mountain of evidence about what people at that time understood different provisions in the Constitution to mean. And then lastly, we can look to the background cultural, philosophical, and religious heritage of Americans in 1787, 91, 1868, and on, to help us gain a thicker context for the Constitution's original meaning. Let me give you an example. So an article I wrote many years ago was about the original meaning of religion in the First Amendment. One thing that struck me is that nobody had written an article on that point, so it's a good place for a young scholar to make a name for himself. And I think nobody had written about what's the original meaning of religion because I think everyone had a caricature of what that meant. Christianity or Protestant Christianity, perhaps. And so no one took the time to actually look into the history. So I looked at the text. Religion is mentioned, of course, in the First Amendment. It's also mentioned in the Religious Text Clause. You look to the Ratification Convention, the Framing Convention, the Ratification Convention, and surprisingly, there was a lot of debate about the Religious Test Clause in Article 6. The Religious Test Clause is the one that says that there should be no religious test for holding public office in the federal government. You look to the larger societal debate. So ministers, for example, argued against the Religious Test Clause. We can't have that because then we'll have atheists in government who don't care how things work. And in doing so, making those arguments, what you discern is that the people in society were using the term religion in a fairly consistent manner. And then, given the background religious, philosophical, and cultural makeup of America in 1791, what I ascertained was that religion meant belief in a deity with a future state of rewards and punishments and duties in this life. So it's a fairly high-level principle about what religion meant. It would apply to belief systems other than just Protestant Christianity. In fact, it was fairly capacious, and in fact, a little bit surprising to me. So that's originalism in the 10,000-foot level. Why be an originalist? And there are as many different arguments as to why you should be an originalist as there are originalists. And it's a little bit flippant. So, for example, one of the strongest arguments for originalism is an argument put forward by Randy Barnett, which says that if the Constitution is consistently interpreted according to its original meaning, the Constitution will best protect natural rights. Some other arguments out there. If the Constitution is interpreted according to its original meaning, Americans will continue to be able to exercise popular sovereignty on an ongoing basis. That's like Keith Whittington. Others have argued that originalism leads to the best consequences, however you define that. And then the last one I'll mention is human flourishing. If the Constitution is interpreted according to its original meaning, then Americans will have the set of background conditions against which they'll be able to flourish as individuals. So stunning variety. Now the challenge of change. I'm not going to belabor the point. The United States today is very different from the United States in 1787, 1791, and thereafter. We're more religiously diverse. We're more urban. We're more industrial. We have new technology. In fact, I think that's what first caught my eye was new technology. How do you utilize a document written primarily in 1787 when you have new technologies like the internet that are so pervasive and couldn't even be imagined by the people who drafted and ratified the Constitution? The challenge of change is a problem for originalism for two reasons. One, because it can lead to injustice, and the second, because it can lead to bad public policy. Here's an example for injustice. If religion meant, as I was saying, future state of rewards and punishments, belief in a deity, duties in this life, there will be groups that will be excluded from the protections of, for example, the free exercise clause, that Americans today generally or universally recognize as being religious groups. Unwise or bad policy. The Commerce Clause, the original meaning of the Commerce Clause meant something like Congress has the power to regulate the transportation of goods and services across state lines. That's a fairly narrow definition or understanding of what constitutes commerce, and it certainly does not fit the jurisprudence or the practice of our federal government. Think of all of the New Deal agencies, New Deal programs that you learn in Constitutional Law 1 and Administrative Law. And the argument would be something like, if we limit the Commerce Clause's meaning to the original meaning, it's going to be too narrow. It's going to limit Congress in such a way that it can't pass legislation that's beneficial to Americans. Social Security Act, or the farm program. The challenge of change is a very common criticism. Scholars who are critics of originalism never fail to bring it up. And I think it's a plausible, or in fact a very strong criticism. But let me offer one caveat before we go on. I think that critics of originalism frequently overstate the case. They say things like, the framers and ratifiers, they're overwhelmingly Protestant Christians, and therefore we can't be stuck with their narrow definition of religion. What I found, though, is that consistently, the framers and ratifiers of our Constitution and the amendments thereafter were cognizant that they were in an ever-changing world. Remember, the framers in 1787, the framers in 1868 for the 14th Amendment had worked against a background where you had periods of dramatic change. After 1776, you had numerous state constitutions that almost all of them failed, or at least were perceived to have failed. And so the framers of the 1787 Constitution wanted to make sure that their Constitution wouldn't fail because of change. And I think the 6 mechanisms that I identify are some of the ways in which they would have used to make sure that the Constitution doesn't go out of date. What are the 6 mechanisms? What are the 6 tools that originalists can use, a justice and Supreme Court can use, to help originalism meet that challenge of change, to change technology, to change social circumstances? First, what I call an originalism of principles. If the Constitution's original meaning is frequently a principle, something that's broad and abstract or general, rather than a rule, something that's narrow and particularized, the original meaning can apply to new and unforeseen circumstances. An example would be the cruel and unusual punishment clause. So from the research that I've seen, the phrase cruel in the 8th Amendment's cruel and unusual punishment clause originally meant something like disproportionate to the punishment. It didn't mean that whatever we in 1791 think is cruel and unusual punishment, and in fact it was a fairly broad rule, disproportionate to the punishment. So the government, which is fairly good at creating new punishments, comes up with a new punishment. That punishment is challenged under the 8th Amendment's cruel and unusual punishment clause. And even if that punishment uses technology that the framers and ratifiers couldn't have conceived of, maybe the electric chair, maybe a certain type of gas chamber, maybe lethal injection with different cocktails of drugs, a judge applying the cruel and unusual punishment clause shouldn't have any problem applying it because the principle, disproportionate to punishment, isn't rooted in any particular context. It's something that can be applied to these new technologies. So an originalism of principles allows originalism to overcome the challenge of change. Second, induced principle originalism. Induced principle originalism is the analysis that originalists use when the Constitution's original meaning doesn't exist. So for example, let's say that the